The District Court of New South Wales is now in session. Please be seated. Case 1 involves the plaintiff at the Shangri-La Hotel, Sydney, slipping on some grapes that were on the floor near the lunch buffet and breaking his ankle, having to undergo surgery as a result. The plaintiff is suing for the total sum of $150,000 against the Shangri-La Hotel for requiring him to be off work for 2 months, unable to earn an income. The incident report noted that the plaintiff did in fact consume a number of glasses of wine before the slip. The court shall now proceed to provide any relevant legislation in which the claim is brought. Could the plaintiff please stand to justify their case?
According to the case that occurred in Scenario 1, the party that experienced the error was Shangri-La Hotel. Because the hotel did not clean up some of the grapes that were on the floor near the buffet food, so the fall from the grapes caused one of the hotel customers, Bill, to have a minor accident, slipped and fell to his ankle and had to undergo surgery. And Bill felt that he was not able to work for 2 months, which cost him $150 of income that Bill's office did not provide. For this incident, Bill, as a customer, sued the Shangri-La Hotel in an Australian court and asked for compensation for the incident, which cost $150 in loss to Bill. So Bill, assisted by his lawyer, to file a lawsuit in an Australian court. According to the case that occurred in Scenario 1, because of the plaintiff, the hotel customer does not get good service to the Shangri-La Hotel. The safety of the customer at the hotel where he stays is one of the responsibilities and obligations of the hotel to serve its customer by the producers and by with the legal rules in Australian consumer law, which is known as consumer guarantees regarding consumer protection in the right to comfort, security, and safety in consuming goods and services recognized by the United Nations for Customer Protection. In the case of Bill who slept at the Shangri-La Hotel, Bill as a customer did not get security, comfort, and safety by the provisions of the Australian Customer Law, which should have the right to repair, replacement, or a refund and compensation for the damage and loss that would invalidate the wrong service. Because of the plaintiff, as a result of the accident that happened to one of the Shangri-La Hotel customers, namely Bill, so the Shangri-La Hotel is purely the wrong party in serving its customer. The fault of the Shangri-La Hotel, according to the Australian Consumer Protection Law, is as follows. The Shangri-La Hotel is in full violation of the Consumer Protection Law by the Australian Competition and Consumer Commission. Regarding the right to comfort, security, and safety in consuming goods and services, in the fault of the hotel, it did not provide security and safety to Bill, who had an accident due to the negligence of the hotel, who did not clean the dropping grapes around the buffet table. Shangri-La Hotel violates the article regarding hotels or resorts must provide maximum service to consumer and not harm consumer. Where the hotel did not provide maximum service to Bill and caused Bill, one of his customer, to have an accident was very fatal to his life. So the hotel has the right to be sued by Bill for compensation for this accident and for what happened to Bill. As a result of the Bill, in this stage, has the right to file a lawsuit against the court in the country where he is staying, assisted by Bill's lawyer with the following stages. Bill, in this stage, in the ACCC, Bill is entitled to consumer guarantees that have been regulated by the law of the competent authority. Because the hotel does not meet the ACCC requirements in the point, hotels or resort must provide maximum service to consumer and cannot harm consumers. So, Bill has the right to sue the hotel In this case, where Bill was the plaintiff and the Shangri-La Hotel was the defendant, Bill has the right to claim compensation for the cost he incurred or be harmed, and if the hotel does not fulfill it, the hotel is entitled to a penalty or sanction that is commensurate with what Bill experienced as a consumer at the Shangri-La Hotel. In the ACCC, Bill is entitled. The legal authorities of ACCC will contact the Shangri-La Hotel as a defendant in the accident that happened to Bill and ask for verification, as well as a request information from the hotel. So, if everything is clear, it will proceed to a trial that brings together the two parties, namely Bill and his lawyer, as a well-representative of the Shangri-La Hotel and assisted by a lawyer selected by the hotel. The legal authorities. In the trial, Bill plays as a party suing for the Shangri-La Hotel where he was staying, which caused him an accident. Bill will explain the chronology of the cases he experienced, which resulted in injury to him, and not being able to work for 2 weeks and a loss in income for $150,000. The Shangri-La Hotel was proven guilty in this case and had the right to identify Bill of $150,000. In the trial, Bill plays as a party suing for the Shangri-La Hotel where he was staying, which caused him an accident. Bill will explain the chronology of the cases he experienced, which resulted in injury to him, and not being able to work for 2 weeks and a loss in income for $150,000. The Shangri-La Hotel was proven guilty in this case and had the right to identify Bill of $150,000. If it does not provide compensation for losses to Bill, the Shangri-La Hotel, as a defendant, is entitled to a sanction or sentence commensurate with Bill's. Thus, in the case experienced by Bill and the Shangri-La Hotel for an accident due to grapes near the hotel buffet, Bill has the right to sue the Shangri-La Hotel because the accident was purely the fault of the hotel for not cleaning up the remaining grapes so far and caused an accident to one of his customers. By law, according to the Australian Competition and Consumer Commission, the ACCC, the hotel does not provide services and security to its customer. The hotel has violated the rules and laws against consumer protection enforced in Australia. So, the hotel is obligated to provide compensation for Bill, and if it does not provide compensation, the hotel is entitled to a penalty or sanction by Bill accident. Thus, in the
A number of evident factors led to the accident upon Bill during his stay at the Shangri-La Hotel, resulting in a loss of work due to the injury. Although the situation of the grapes on the floor being put into question by the plaintiff, it is also extremely important to understand the inebriated state that Bill was in at the time of the accident. The plaintiff had consumed a number of alcoholic drinks beforehand, and thus could have led to an impairment in his judgment, which without could have mitigated the fall. This is noted in a similar case in a Newcastle hotel, where a man had slipped on the dance floor due to an undermalt spillage. This is an example that is able to prove how long the mitigating factor of the puddle was there for, and how there wasn't a clear process in place to clean the mess. This is unlike our plaintiff, who has no proof of the grape's time on the floor, and therefore is one factor as to how the defendant can't be held accountable. Under Safe Work Australia, you are not allowed to claim any personal injury compensation if an accident was ultimately caused by your own actions. It also needs to be noted that simply taking the word of the plaintiff isn't enough to prove beyond reasonable doubt, and henceforth needs to show evidence of the grape's time being there for a certain amount of time before the fall. When thinking in a reasonable manner, it is safe to assume that the plaintiff can prove beyond reasonable doubt that the hotel was negligent in cleaning up the grapes, was aware of the mess, and if, ultimately, the plaintiff was unable to avoid the situation, then he should be compensated. This is not the case here, as proven by two factors, including his state of mind due to the alcohol consumed, an overall sense that the injury is caused by his own fault and not that of the banquet management team. Overall, it's clear to see how these factors have shown and been able to prove in detail into some of the issues surrounding the plaintiff's case upon the matter.
Under the New South Wales District Court, the two sides of the case, the plaintiff and the defendant, undergo the relevant jurisdiction in which the claim is brought. From what has been mentioned by the plaintiff is the reasoning behind the Shangri-La Hotel being at fault and negligent for not cleaning up the remaining grapes that fell on the floor, resulting in one of their customers slipping and hurting themselves. Although the defendant also mentioned that under Safe Work Australia, you can't claim personal injury compensation if an accident was caused by your own actions, the incident report justified that the plaintiff had in fact consumed a number of wines beforehand, so the behaviour and state in the time leading up to the accident in some way contributed or caused it. This court is dismissed. Thank you.